Well, good evening, everybody. Give me a minute to get everybody on board here. Good evening, everybody. Give me a minute to get everybody on board here. Give me a minute to get everybody on board here. Yeah, Philip, Pat, Gilbert. And I think, is that everybody on there? Let me hide this other page. Hide. It's 5 of us, right?
There should be.
There we are. There we are. Well, welcome. I'm Ed Levine, and with us tonight we've got Phil Van Cleve, the president of the organization, Pat Webb, the treasurer and secretary. She runs the treasury, so I got tongue-tied there a little bit. We have board member and gun attorney Gilbert Ambler, and we have board member and gun attorney Jim Pierce. And what we're going to do is talk about a couple of shootings come through our desk on the internet, and then we're going to talk about some things. We'll let the lawyers speak, and we'll talk about some things like castle doctrine and stand your ground and codified law, and then some things in general, some lawsuits we've got going on. But what I want to tell you also is, while we're going to talk about legal things and their possible ramifications, this is an informative show, and what we say or what the attorneys say, while it's probably factually true to you, it's not necessarily true for you and your current situation. So it's not legal advice for you. If you need a lawyer, we certainly would like you to seek out a lawyer, whether it be John or Gilbert Ambler or whoever it is, rather than use this video as your legal counsel. Okay? So, that said, as running the social media, I get a lot of things come across my desk, as does Philip. And one of the things that came across was a shooting. If you don't know what it was about, it was a shooting that was in Ohio, and basically a voicemail was left for a girlfriend. The boyfriend came over later when he was unwanted, and came to the door, rang the doorbell. They didn't want him there. I don't even know if I'll have to show the whole video, but it's here in the corner. And I'll sit quiet. It's 4 minutes. I don't really take 4 minutes up. I'll try and get to let it show the nitty gritty. And I don't know how well you hear it, especially if you're talking. But basically, can you guys see that?
Yes. Yes.
Yeah.
A ring doorbell camera captures the terrifying moment when a woman's ex-boyfriend is shot and killed by her father. It happened on
You
July
guys might all have to
31st
mute so
in
there's no
Sydney,
echo.
Ohio. Allison Duckrew says she and her mother returned home from breakfast when her ex-boyfriend approached the front door.
I think that's yours, Ed.
When no one answers the door,
the man starts to get physical.
Through
all
all
this,
Allison
places a call to 911.
There's some guy on my front porch. He's behind his back. He's answering on the ring. He left me a voicemail on my phone last night.
That voicemail came from 22-year-old James Rail, who Allison says she dated several years ago.
Hi, Alan. It's James. I just wanted to reach out to you.
All right. So I know that's a little bit hard to hear, but the bottom line, and we don't have to watch the full 4 minutes, but bottom line is the kid came to the door. He wanted. He pushed himself in. The girl's father announced, "I have a gun," and the boy continued to push himself in, and he got shot. It looked like 2 or 3 times, 2 times, and as he was turning to run, the third shot looks like it may have hit him in the back. I don't know. and you have the neighbor coming over saying, oh, he's all right, let him get up, and walking all over the crime scene or whatever. Just a lot of things going on. So keep that in mind. That's one video we're going to talk about, the kid on the front porch. The next one that we want to talk about comes to us, and this will really be hard to see, but you might see it a little bit. It has to do with, I don't even know if it's going to play because it came to us through a Facebook reel. Yeah, that one's, I don't think that's going to work, but we can still talk about if this. So what that one was, the Facebook reel that was sent to me, was a guy's in his house apparently. It looks like a lawn worker with a weed whacker comes up to the door. It almost, the way he's walking, it almost looks like he's got to use the restroom. And he was just looking to see if someone was home. And he comes up, kind of looks in the door, then opens up the door real quick. The guy comes out of the house with a gun going, get out of here. And Gilbert and I already told this very calmly, like, hey, get out of here. Look, you got 5 more seconds. 5, 4, grab your stuff and get out of here. 3, the safety's off. 2, and obviously the guy grabs his stuff and runs. Then it hits the guy like, oh my God, this guy just walked into our house. And then he starts telling that to his wife or partner in the house, like, the guy just walked in the freaking house and I have the gun here, blah, 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 blah. So why those 2 videos? Because these could be things that happen in Virginia, and on a daily, pretty much a daily basis, we get questions through the website, through the Facebook, through all the other social media, through email, through our website contact page. What if that Virginia? What do I do? I have U.S. Law Shield, or I don't have U.S. Law Shield, or I have one of the others, and I just don't know what to do or what to say. People were asking in the forum, if this happens, what should I tell the police, that I was just going to do this? And then there's an argument, well, you shouldn't say anything to the police. You should talk to your lawyer. So that's the reason for tonight. If I talk too long, I'm sorry, but that's what we're doing tonight. So I'll let John introduce himself, talk about him, his background, and what's going on with him and his law firm. Then we'll have Gilbert do the same, and then we'll have you jump right into however you want to tackle either the videos or Castle Doctrine or Stand Your Ground or any of those type things. Go ahead. If you're unmuted.
There we go.
Oops, no, you remuted.
I'm sorry.
Now you're back.
Now you're
now
muted.
He's muted. Hang on. I'll unmute John. Hang on.
Can
All right,
you hear
John
me?
is now unmuted.
I think that I was clicking to unmute and you were unmuting me at the same time, and we were going back and forth. My name is John Pierce. I'm an attorney. My office is in southwestern Virginia. However, I do practice statewide. I do a great deal of practice in the Richmond, Northern Virginia area, but I think I've been in all but about 3 counties statewide over the course of my practice. I do a large number of NFA and gun trusts. I also do gun rights restoration cases and any other firearm related cases. Obviously, a lot of people, when they think about firearms cases, they immediately go to self-defense cases. But in reality, hopefully your average gun owner will have the foresight to prepare properly so that it will be a last resort having to use deadly force. So that's actually a fairly rare event. And I know when Gilbert's introduced, he's going to talk some about some of the different insurance programs, but those are for use after you've had a self-defense shooting. You shouldn't be thinking about, should I or should I not shoot based on having insurance? If you're having that thought, you haven't thought it all the way through. So anyway, we're going to talk about the facts surrounding this and how it would apply in Virginia. and we're going to try and split that up. So I'm going to go ahead and let Gilbert introduce himself.
Thanks, John, and it's a pleasure. I'm looking forward to doing this evening because John and I talk on a regular basis about a number of different firearms cases, and so I know that we're probably fairly closely aligned in what we think and what our advice is going to be tonight. Like John, I practice in Virginia doing mostly firearms cases. Personally, I handle almost exclusively firearms cases, although my office handles a wide range of criminal defense and family law issues. We're based out of, unlike John's in Southwest Virginia and practices statewide, I'm in Northwest Virginia and also practice statewide. So I bounce all over the place, not just in Virginia, but also in Pennsylvania. So I actually split back and forth between a couple of states. And like John, I handle, when we talk about everything firearms related, I handle interactions with the ATF, both on the individual level as well as for federal firearms licensees or for gun stores. I handle self-defense related incidents. And that's everything ranging from fistfights on the low end all the way up through self-defense shootings at the most serious level. And John sort of gave you a little foreshadowing. One of the organizations that I represent is U.S. Law Shield. And so I do see a number of self-defense incidents that come through my interaction with U.S. Law Shield. And one of the things I really enjoy about representing U.S. Law Shield members is that I have the ability to be on the phone and connecting with them in the moments after something happens, as opposed to most criminal defense attorneys who wind up involved the next day or the next 2 days or 3 days later after a lot of the damage has been done. And so I think some of what John and I are going to talk about tonight is not just good advice for Law Shield members, but good advice for anybody who's a gun owner in starting to think ahead. Hey, I hope I'm never involved in something. I hope I never have to actually, it's one of those things, you own a gun, but you hope you never have to use it in a defensive capacity. But if you do, what steps should I take? What's the smart thing to do? And how do I best protect my interests? Because so frequently when I deal with self-defense cases, the first thing that I have to do, the first challenge I have after a self-defense shooting is convincing my client, the person on the other end of the phone, that they are now a suspect in a criminal investigation. Because when you leave the house and you're not thinking, hey, I'm going to wind up shooting somebody today, and you get backed into a corner and forced to act in that scenario, what I find is that when police show up to the scene, most civilians, the light bulb has not yet gone off in their mind that they are the suspect in a very, very serious investigation. And the sooner they realize they are the suspect in a serious investigation, the better we can protect their rights. And I'll talk a little bit more about some of the things I've seen over the years doing this, but that gives you a quick background on my perspective coming into this.
All right, thank you both. And I do want to say that while Gilbert represents U.S. Law Shield, on the VCDL webpage, under resources, there is a legal comparison. So while U.S. Law Shield is actually who I use and it's right for me, it might not be right for you in your particular circumstances. And we have done some promotions with U.S. Law Shield where we members get a discount and then we get some money back. So that's all transparent. We talk about that. That's nothing secret. And then I want to ask John one more question about his introduction. Can you tell us what a gun trust is and what it's for?
A gun trust is simply a trust that is specifically tailored to the ownership of firearms, whether it's regular type 1 or type 2 firearms. They both can go into a similar trust. There's really two types of firearms from a regulatory perspective here in the U.S. There are regular firearms, handguns, shotguns, rifles. Then there are NFA firearms, suppressors, short-barreled rifles, short-barrel shotguns, machine guns. And primarily when we talk about these, but not always, we're talking about NFA items because the regulatory burden on those is so much heavier that if you wish to be able to share them and ease their passing to the next generation or whoever your beneficiaries are, then the trust offers extensive benefits.
Okay, thank you. Philip or Pat, do you have anything before we jump in?
I don't, other than to mention we do have a couple of questions already in the chat window.
Okay.
Yeah, I don't have anything. I don't have anything. Go ahead.
So Michael Dalton has a question. Is there an accepted distance from your home porch that is that your curtilage extends?
I'm happy to jump in on this, and if John has more, he can back me up or disagree with me, or we'll see where it goes. But it's not. There's no black and white measurement. No one's going to get out a tape measure and say, hey, people talk about the 21-foot rule, which is a terrible term, and of course a very different context from how far curtilage extends. But in any of these things, it's not absolutes. It's not black and white. It's going to be an argument over whether you were in the area, in the part of your property where you typically would associate some of the privacies of your home. And one of the biggest cases where they really discuss curtilage of the home is not a case that involves self-defense, really. It's more of a concealed weapons case, because there's an exception for having a concealed handgun if you're in the curtilage of your abode. And there was a case called Commonwealth v. Foley where they discussed how far curtilage extend. They declined to give a distance measurement, in response to this question. But they did say in Commonwealth versus Foley that the gentleman in that case was outside of the curtilage of his home because he had walked down the front bank of his house, across another roadway, another easement, and was sort of in an area where he's pretty detached from the area immediately surrounding his home. I encourage people as much as possible, when you're talking about, hey, how far should I expect to have sort of the extra, and this dives into what the Castle Doctrine does for us, because the Castle Doctrine is simply a very specific application of our justified use of deadly force laws. But when you're thinking, hey, maybe I'm going to get a little extra leeway, people might lean my direction a little bit because this involves my home, I would be very, very tight around the home itself. When you're on your front porch, you're probably in the curtilage. If you're on your back deck with a hot tub there, we're in your curtilage. Once we get beyond that, once you step off the front steps of your porch and start walking down into your yard, into your driveway, into your backyard, I'm happy, if it's a defensive case, understand we might take a stance that is part of your curtilage because that's going to help our argument, and perhaps we will be right. But if I'm giving you advice preemptively and trying to tell you ahead of time how to plan, assume it's as tight around as your house as possible. You don't want to be extending that zone, because as you extend that zone, you're increasing your liability. The further you step from your house, the more it will look less like you're defending your lives and your property, the more it will look like, hey, you hated this person because they were on your front lawn. And so my advice is keep it as tight as possible. John, I'll let you jump in.
Well, I was just going to say, in Foley and in subsequent cases, the Commonwealth has largely adopted the four-part test that the Supreme Court laid out in a case called Dunn. And those four-part factors really kind of track with what Gilbert was saying. The first factor is just the physical proximity of the area that is claimed to be curtilage. Number two, whether it is included in some kind of an enclosure. Is there a fence? Is there some other, maybe a hedge that encloses the area? Number three, what is the nature of the uses to which the area is put, right? Is it an area where all the neighborhood kids come and play football? That's not going to be curtilage. Is it, however, an area with a large hedge and, the family goes out into the pool or the hot tub and skinny dips, right? So they're trying to treat it as a private space. And finally, attaching to that, the steps that have been taken by the homeowner to protect the area from observation by the public. And so if you, as Gilbert said, if you get outside the area that you have sort of boxed in surrounding your home, then you're going to be outside the curtilage. At one time, I owned a very large piece of property, about 82 acres, and my house was in the middle. And so, I could go a decent distance from my home and still be very much in the middle of my property. But just by being in the middle of my property, that's not going to give me the same protection as if I were on my back porch, which is gated off. So those are the factors you want to think about.
And I would add on to what John's saying, that maybe when we're talking about curtilage in terms of concealed carry exceptions, this becomes more important. But if your defensive use argument relies on whether you were not within your curtilage in Virginia, I think you're already on a pretty iffy territory. Okay. You don't want to be to the point where your case is so iffy that it becomes critical to establish, hey, I was actually within my curtilage. Because if that's what we're arguing about, we're in difficult territory. Our laws are pretty good in Virginia, both within the home and outside the home. And the benefit to that is because they're pretty good outside the home, you don't have to establish that you were within your curtilage to be justified in most cases in Virginia.
All right, thank you. That curtilage question comes up a lot, kind of like the misnomer that you have to be in fear for your life. That's what everybody says. Every non-lawyer people are like, well, were you in fear for your life? I'm like, well, you don't have to necessarily be in fear for your life to shoot back. But that's one that comes up all the time. So another question just came up. I'm sorry. Go ahead.
Go ahead. I'll let you move on. I'll make the point while we're here. I think that I was in fear for my life thing, which, sort of picked up, and there were instructors telling people to say that if they ever discharged their firearm. And I think we've gotten to the point where prosecutors, for the most part, say, yeah, heard that one before, because it's become such a standard line. And so I don't think it is. I mean, look, if it comes out of your mouth and it's true, it's probably not the worst thing in the scale of bad things to say. But I don't think it's going to help your case to be saying that in the immediate aftermath of a self-defense incident.
Right. Can you explain the difference between stand your ground versus the no retreat rule?
So let's just kind of to take a broader picture of what we have in Virginia, right? The terms stand your ground, no retreat, other things like that have been used to talk about and define other states that have statutory frameworks for self-defense. And, I actually went to law school in Minnesota. And while I was there in law school, I helped do some lobbying there. And they had a very robust statutory self-defense law that tried to lay out the framework by which someone could claim self-defense versus when someone couldn't. Here in Virginia, we're very much a case law driven state. So when we're talking stand your ground versus no retreat in Virginia, we're really talking about the duties that are imposed upon you in certain circumstances and under specific case law scenarios. And the question is, under a given circumstance where you are faced with threat, what are the options that are available to you? And are you, in fact, obligated to take advantage of those options to avoid the taking of a human life? Right? So stand your ground, no retreat. All those really mean is in situation X, under certain states' laws, you are not obligated to retreat, even if you have the opportunity and can safely do so. You're not obligated to retreat. And I would encourage people who are listening, even if they're not in Virginia, to start from the point of, if I can safely retreat and not leave any innocent third party unprotected, then whatever rule applies, I'm going to retreat, because you are going to end up with an emotional cost, a financial cost, paying someone like me and Gilbert a lot of money. You're going to end up with a cost in your neighborhood in terms of how your neighbors are going to view you, etc. Self-defense shooting should always be a last resort. The great thing about America and Virginia in particular is that we do have that last resort option, but you should always look to it as a last resort. So even if you have no duty to retreat in a given circumstance, you can safely do so, do so.
And John touched on, Go ahead,
Go
Pat.
ahead.
I was saying,
I was
John,
gonna.
John
Jinx.
touched on some of the moral and sort of the emotional costs and some of the collateral costs that people don't often consider. But when we're talking about a duty to retreat or whether there's a duty to retreat, which as John just told you often, and we'll get into, I'm sure as the evening goes on, we'll get into specifics on when there is a duty to retreat. But often in Virginia, there's not a duty to retreat. But boy, does it look good for a self-defense shooting if you first did everything in your power to get away. I mean, if we're worried, you know, a lot of times when I first talk to somebody who's had a self-defense incident, there's certain flags that really causes my concern to go up. For example, if the person you shot is somebody you had a pre-existing relationship with that person, the flags start going up. Chances of prosecution are starting to go up. But if you first did everything in your power, and we can demonstrate ultimately, if we have to a jury, all the steps that you took to try to escape, to try to avoid using deadly force, and you were truly backed into a corner, even if there's not a legal obligation to retreat in that context, I feel so confident going into that, because I struggle to see how a jury is going to convict somebody when there's a true threat of death or great bodily harm, and someone has no obligation but did everything in their power to avoid using deadly force. So it's something you should do, not just for the moral and other collateral issues that John talked about, but because it's going to strengthen your case, even if you're not legally obligated to.
And you know, it's tough enough emotionally if you have to, if you're a victim of a crime and you pull your gun in self-defense and you didn't have to fire a shot. That's a huge emotional burden you have to bear. But if you actually take a life, even if it's in self-defense, 99% of us are going to really suffer some emotional damage to that just because you were forced to do it. Nobody wants to have to take a life that I know. I'm sure there's some people out there that do, and those are the people that we're defending against.
Well, I know at meetings, Philip Conley, you know, with road rage, especially up here in Northern Virginia, he's always said, you know, if you're driving down the road and somebody cuts you off, and you know, for your brain for a second gets mad and you beep your horn and flip the bird and whatever, now you're part of the action. So if the guy gets out of his truck and, you know, comes after you with a crowbar, since you had the bird flipping and the waving in the hands and the beating, you kind of have it, and correct me if I'm wrong, because you're now part of it, you have a duty to retreat as far as you can and get away from that guy, even though, like John said, that would be a good thing for you to do anyway, but you have an obligation to do it since you were kind of part of the argument. But if you're just driving along and there are no beeps and there are no one finger waves and the guy comes out with the crowbar, you're at that point, as I understand it, not obligated to, even though you might want to, you're not obligated to retreat and you can stand your ground. Do I got that right?
Yes and no. I don't think it's quite as clear cut as, hey, I had any negative interaction is going to trigger the duty to retreat. That would be painting with too broad a brush. Beeping the horn at somebody, the question is going to be, was it reasonably calculated to bring on this affray? Was it reasonably calculated to start this? Now, this is where reasonable minds can differ, and certainly prosecutors can have a very different version than John or I might have, because John and I are probably going to take the stance united on this front that beeping at somebody is not reasonably calculated to bring on a deadly force encounter. But do you run the risk that there's some prosecutor out there that takes the stance that, hey, really, you were the one who got this started? And let me point out to you, it might not even be the prosecutor alone, because eyewitnesses are notoriously unreliable. And you might have done something very, very simple, and somebody might have perceived it incorrectly. They might have thought you were swerving at the other car. Or even worse, there's people out there that just flat out lie, that like attention and want to say they saw the whole thing and make up facts. I've dealt with it on cases before where there's people that want attention for themselves and are fabricating facts just because it brings attention. They get to say they saw the whole shooting play out before it started. But these are all risks you run. And so if you can drive away from it when somebody beeps at you, that would be my advice. I think that's what you should do.
And I'll add to that two things. One is, I believe what the Supreme Court of Virginia said about that topic was self-defense is the law of necessity, and that necessity must not arise out of your own misconduct. And again, it goes back to, is beeping your horn actually misconduct? And I would argue that it is not. But I'll give you an anecdote from a case that I did several years ago, where a client of mine did just that. A person pulled in front of him, no previous interaction. They pulled in front of him. He beeped his horn. They then brake checked him, and things began to escalate between the two of them. And my client became angry and was making rude gestures out the window. The other person, as they came around him, had noticed that he had gun stickers on his vehicle. And they thought, you know what, I've got a 50-50 shot. They called the police and claimed that he had pointed a firearm at them. The police, when they pulled them both over, amazingly enough, gun owners carry guns. And all of a sudden, he's charged, and he had to pay me a great deal of money to make that no longer be there. Thankfully, there was insufficient evidence that he had done anything wrong. But having said that, it isn't guaranteed to work out that way. Because those of us who are gun owners and permit holders and who carry on a daily basis are going to have guns, then we have to behave even better than we should in other circumstances, because, as Gilbert said, people will legitimately lie if they're angry at someone and they know that they're carrying a gun. That's another lever or crowbar that they can use against them.
And I sort of joke with people talking about, John's talking about this case he had where, the road rage type incident where somebody called it in and made up a story to get somebody else in trouble. And I will tell you, I've had a lot of cases with identical fact patterns, essentially. So it is a very, very common thing that on the roadways, when things go wrong, someone makes up an allegation. And once you get pulled over 5 miles up the road and you do, in fact, have a handgun with you in the vehicle, the police are going to view that as corroborative evidence. That's evidence that corroborates the story they just heard. And so I joke with people. I tell them, look, I'm not telling you should go carry a pink Muddy Girl camo gun, but that's one good reason to carry a pink Muddy Girl camo gun, because if somebody makes up an allegation that you pointed a gun at them, it's invariably a small black handgun that was pointed out the window. So when you show the officer your pink Muddy Girl Ruger LCP, you should have the evidence on your side. So I'm teasing, but gun stores, if you stock Ruger Muddy Girl LCPs, there's a utility for them as well.
Also, an advocate for carry a digital recorder or have dash cam and more proof that's going to prove your innocence.
If you're right, John's talking about, you've got to be better than the rest of society if you carry a firearm. I like to tell people there's an old saying, an armed society is a polite society, and it has to be true. And especially it has to be true if you're carrying around a recorder, because that evidence is great if you're doing everything right. It's terrible if you start messing things up. And I have, a lot of times I get that question, should I carry some type of video to record what I'm doing? Yes, if you're confident in your behavior. If you're going to misbehave, then no, absolutely not, because it gets used against you.
So just the fact that somebody says that it's a small black gun pointed at them is an indication that they're not telling the truth, because when a gun is pointed at you, it looks huge. But we did get a question earlier that said there are legal plans that some employers provide, and is that the same as something like the legal plan for U.S. Law Shield? And I would say it depends on the plan. If it's just one of those legal plans that does wills and trusts, regular trusts and deeds and things like that, probably not. The advantage of using something like U.S. Law Shield, USCCA, or any of the other ones on our legal plan comparison is that those particular organizations specialized in firearms law and self-defense law in the states that you're in. So, yeah, go ahead, Gilbert.
Yeah, I
'cause you're
agree
the
with Pat.
expert on it.
I obviously, have some bias or, because of who I represent, but that's not to say that the other plans out there are bad plans. There are bad plans out there. I'd encourage anybody to do their research and make sure they know what they're getting. But there are absolutely other good plans as well, in addition to U.S. Law Shield. I think that really what we're talking about is a helpful thing because people are starting to think ahead, irrespective of what plan you wind up choosing. Because once you're starting to think ahead, you're starting to demonstrate some of the characteristics that will help things go well for you after a self-defense incident. If all you've ever thought about is the tactics on the mechanics of how do I actually draw my firearm and press the trigger and confront a threat, and that's the furthest your thinking has progressed, you're in for a very, very rude awakening if something does occur, because it's going to be difficult. And irrespective of what plan you look at, you should start thinking, how do I prepare for the aftermath if one of these ugly encounters actually occurs to me?
And I'll even
Serge,
go a little bit further.
I'm going
Well,
to
real
disagree
quick,
with
Ed,
Serge
just
on a
to-
couple things. He
just
says,
to-
good thing not many people know about VCDL. I would say that's a bad thing, number one. Number two, there's over 100,000 people know about VCDL, and probably half of them are very proud members that don't mind displaying their Gun Save Lives stickers or whatever else on their vehicle. They don't have to, but they do so proudly. And unlike people think, their cars are not broken in all the time or scratched all the time or whatever else. Because if you believe a person that has a truck or a car that's got a gun sticker on it, if you believe that they carry a gun and they're around with their gun, whatever, you got to be pretty ballsy to go and mess with that guy or his stuff. I'm not saying you protect property with firearms, but there's plenty of people that love our stickers on their cars and they're proud members. So I get it. If you don't want to put a sticker on your car, then don't. But and I'd say it's a bad thing that not a lot of. I would like more people to know about VCDL. We'd get more of our laws through and stop some of the gun control that we have coming our way. So, and swatting is illegal, Cheryl. You just can't call up and say someone's a bad person, think they did this. Because generally when you're swatting, you're telling a lie about the person to cause them undue harm and harassment. Here's a question we get asked a lot about from Militant about signs on stores. If you're when I go in that store, I don't look at what credit cards they take or who the manager is or what the hours are. I just open the door and walk in. I'm not reading all their signs to see if they have a slash through a revolver, which I don't carry. So I'm like, okay, no revolvers, I'm good. Do the signs have the force of law?
I'll let John take the lead on that one because I want to answer a question that is getting a little bit buried in the group chat that I don't want to miss, which was somebody commented and said, hey, the Virginia Supreme Court has been very, very clear that words alone will never give somebody reasonable belief that they have to use deadly force. And they're absolutely correct. Words alone will never suffice to give you reasonable belief that you have to use deadly force. And so the question was, if words alone will never give somebody reasonable belief that they have to use deadly force, why might I view the threat as the threat if I was just jawing, if I was just talking at somebody, but didn't do anything else? And the answer is because prosecutors are going to argue, because that's what prosecutors do. They take a side, they argue their side. They're going to argue the same way that they might argue against you if you were using deadly force based on words alone. They're going to argue in reverse that the words provide context for everything else that was going on and that there was a valid reason to view you as instigating this, and therefore you lose the benefit of justifiable deadly force and you're confined to excusable deadly force, which you do not want to be confined to excusable deadly force. Anyway, I didn't want that to get buried in the group chat. I'll let John take the lead because I've been talking a lot on the no gun signs, and then we can move on.
Sure. So whenever you have a store, and again, we're talking a privately owned, we're not talking a store that is a gift shop inside a government building or something like that, but we're talking about a privately owned store and they have a sign, maybe no shirt, no shoes, no service. And then over here, they've got a no gun sign. What they're really doing is they're giving conditions on the right of entry to their business. However, while that is potential evidence that you've been put on notice, as people have stated, you don't read every notice on the door of a store you walk into. In many cases, you walk up to the door, and we're so used to seeing things, we just walk on in. And so when you're not dealing with a statutory prohibition on having a firearm there, so in other words, Virginia doesn't have a statutory law that says you can't carry a gun into a shirt store, and you go into a shirt store and they have the slash sign, that is going to be enforced through simple trespass law. And in order for trespass to lie against a person, they first must get notice. And after having been given notice and reasonable opportunity to depart, they either refuse to depart or they return after having been put on notice, at which point they can then be actually charged with trespass. People get trespass confused because we use it as a verb. And so, when you're trespassed, that's really means you've been put on notice not to come back. And then after that, you're charged with trespass. So if you have not been given notice, proper notice, then those slashes don't have any force and effect. But again, as Gilbert said, prosecutors, they might argue that it was large enough and prominent enough and there was a single entrance, and maybe this store has been in the news enough talking about their disdain for carry that any reasonable person would have been on notice. So you have to be a little bit careful about that.
And even proper notice means it has to be by the owners or their agent. So it might not be just a waitress unless she's been an owner or an agent. But if she's just like, oh yeah, the owner doesn't like that, you need to get out of here, she might not be a proper agent, but
the waitress is probably going to have agency for that purpose. If she's on payroll, she's there working, she's probably going to have agency. I would advise you to leave if a waitress told you to leave. I will just piggyback on what John's saying. As part of what I do, I'm always advocating for people to exercise situational awareness. I think it's a good thing for them to keep their heads up, look around when you're walking through parking lots. The only exception to that is that if you're walking into new businesses that may or may not have no gun signs, that are private businesses, that's a pretty good opportunity to be on your phone sort of scrolling as you walk through, because the last thing I want to see is you get charged with trespass and the prosecutor turn over to me a video with you standing in the doorway, looking around, reading the sign carefully, and then walking in, because that's going to help them. Again, they've got to prove notice. And if they get that video of you standing there sort of running your finger over the sign, that's going to really support them, showing that you did have notice and therefore were trespassing in that scenario.
So I want to interject a couple of things here. One is, suppose just a scenario, you go into a store and you're open carrying, or you're printing, or somehow somebody notices that you're carrying a gun. And the store doesn't have a sign posted at the entrances. And they ask you to leave, and you say, well, it's not posted, so I don't have to leave, or something like that. Don't say that. Don't suggest to them that they posted, because then that ruins it for other people that may go to the store concealed carrying and nobody notices. So the other thing I wanted to say, kind of segue into, John alluded to something about statutory prohibitions versus private businesses or private property prohibitions. And we do have the local governments are able to make statutory prohibitions in their county buildings and parks and things like that, but they must be posted at all of the entrances. And if they're not posted at all of the entrances, it's my understanding that they're not enforceable. Is that correct?
I think it's going to serve as a defense. Defenses don't stop you from being arrested.
Right.
And so if it's not posted, yes, Section F, I believe it is, of 15.2-915 requires notice to be posted. But lack of notice isn't going to stop the arrest. That might help you win in court, but then you're still going down the road of hiring lawyers and all of that stuff. The only benefit is if you get arrested for carrying in one of these locations, you definitely have standing to challenge the constitutionality of the law. So, I'm not advising anybody to break laws for the purposes of obtaining or manufacturing standing. But hey, there's fringe benefit. I'm a glass half full guy.
And the difference there too is that they don't have to ask you to leave before they press charges. They can just arrest you for being there, as opposed to a private business would have to ask you to leave, and if you refuse, then you're guilty of trespass.
Yeah, you kind of have to go out of your way to get in trouble for trespass in a private business.
But doesn't DMV have to ask? Doesn't DMV have to ask you to leave if you're carrying there?
Not anymore.
Not anymore.
When they
That's just 2020.
Yeah, when they first posted the DMVs, when it was the executive order, yes, they had to ask you to leave, and it was similar to the
DMVs and ABC stores.
Mm-hmm.
And remember that the asking to leave stuff can still be taken away if there's adequate, as John was talking about, adequate notice otherwise. So if prosecutors might argue, hey, if everybody's talking about how Buffalo Wild Wings just put up no gun signs and it's common knowledge, everybody knows, and they had it posted in giant red on the door that you walked through, then they might, there's a good chance that they might skip the, hey, we're asking you to leave stage and proceed straight to asking you to be charged stage.
I think mostly, though, police aren't real interested in they prefer, I think, before they arrest you, to make sure that they ask you the question one more time and get an answer from you. No, I'm not leaving. Then it's clear for them. It's easy, as opposed to arresting somebody and then finding out, well, no, you didn't know.
That's probably true, although it also depends on the jurisdiction. There's jurisdictions.
I was going to say, Alexandria, you might not have that luxury.
I don't know again, we're talking about police here, not the city council. But, you never know for sure. There's no guarantee. I also see there's a question here about Paul Woodall is asking a question. Is there a Virginia law that if I voluntarily go get mental help, is that held against me? And I'll let our two attorneys comment after I do. My understanding is that, if you go to get help in a residential setting, like if you're an alcoholic or something like that, and you go to a residential setting, you lose your right to get a permit for a concealed handgun for 5 years. And that's pure BS. We need to fix that. They should never make it so that it's a penalty for you to voluntarily seek help, whatever that is. If you penalize somebody, they won't get the help. But I think generally, but you don't lose your gun rights for doing that. You just lose your ability to get a concealed handgun permit. And I think getting help voluntarily doesn't strike down, your ability to do either if it's not in a residential setting. Guys, one of the attorneys commented.
Yeah, this is one that it really bothers me where we stand in Virginia on this. Let's start with just a general statement. And Philip is correct about the 5-year prohibition on the concealed handgun permit following the date that you get out of a residential treatment facility. But again, if you went there voluntarily, in general, it doesn't take away your regular gun rights. And the same is true under federal law. Under federal law, voluntary mental health treatment does not take away your gun rights. Virginia, however, is one of the states that goes a little bit further, and the way we do it actually leads to a lot of people getting in trouble. And here's why. We have something in Virginia called a temporary detention order. It's a 72-hour evaluative order where if and this predeceases the discussion of red flag laws. These have been around for a long time. And in point of fact, when everyone is concerned about red flag, we almost never see those being used in Virginia. It's TDOs and ECOs. And if you are brought in on a TDO for mental health evaluation, there's 3 ways that will end. The first way is that at some point during those 72 hours, they determine that you need to be involuntarily committed. At that point, you've lost your gun rights. The second way that a TDO ends is that you go through the evaluation period and it is determined that you can go home. That's very rare once a TDO has been granted, but it happens. At that point, you retain your gun rights. But the insidious one is you get near the end of the 72 hours and they're like, you know what? If you'll just voluntarily agree to go see this counselor for the next 4 weeks, we'll go ahead and let you go. Under Virginia law, if you are held on a TDO and then voluntarily agree to attend mandatory outpatient treatment, you leave there without your gun rights. And I get so many clients who has that happen to them, and they call me up and they're like, I voluntarily agreed to get treatment. I was not committed. And the answer is yes, but if you read that question on the SP 65, it doesn't just say, have you ever been involuntarily committed? It has this whole other paragraph after it that says, or have you been held on a TDO and subsequently agreed to voluntary outpatient treatment? So that's something to be careful of. One other thing I run into quite frequently, and I honestly don't know if this is still a problem or if it was a problem years ago, and we're just now seeing people that are reaping the fruits of it. But I've had a number of clients that say they went in for voluntary treatment, and when the hospital was bringing them on board, they gave their insurance, and they said, well, the only way we can get this covered by insurance is if we have you meet with this panel of doctors and they decide to see you. And that, in fact, turns out to be a commitment hearing. Again, what we're really doing is we're taking people that are in a crisis point in their life. Maybe they're depressed. Maybe they've had a death in the family, whatever it is. They're reaching out for help. They're flailing around. And then we come back 10 years later and we're like, if you don't remember the exact legal situation that you left that facility in, we might charge you with the felony. It's extremely unfair, but when you're talking about that voluntary thing, don't paint with a broad brush. You need to look at the details with someone like me or Gilbert.
And I've got a final category, which is people that are attempting to obtain a concealed handgun permit and don't read the form carefully. Because I think John and I have both had people that have not read the form carefully, had purely voluntary interaction, not in a residential setting, more than 5 years ago, not something that would statutorily affect them, but they don't read carefully, they answer incorrectly, and then they get denied because of how they answered the question.
Including marijuana now. We talked about, Gilbert did like a 15-minute thing. It's on our YouTube channel, but you want to do a quick summary about marijuana and guns in Virginia and permits?
Sure. It's marijuana and guns everywhere. It's not just Virginia. And that is because the federal government considers marijuana to be a controlled substance. And as such, if you are a user or addicted to a controlled substance, and again, this is irrespective of what the state says, so whether the state has legalized, decriminalized, made lawful for medicinal use.
Medical card.
The feds say it's illegal, and if you are a user of it or addicted to, it becomes unlawful for you to be in possession of firearms.
One other thing I'll add about that I've ran into recently that I believe is a violation of due process, but nonetheless, it is in fact how the NICS system is ran. If you are arrested for or convicted of a drug crime, and you notice I said arrested or, you could be arrested and then the charges dropped, it doesn't matter. Once that gets entered, there is a 365-day presumption that you are an unlawful user. And so let's say that you get arrested for possession of marijuana, and you go to court and you prove that in fact it was, I don't know, ground time, and you're a professional chef and you were carrying it around with you. I don't know. But you were found not guilty. And then you go the next month to try and buy a gun. You're going to be denied because there is still a presumption banner that is in the NICS system that will stay there for 365 days that presumes that you are an unlawful user. I even had one case which absolutely floored me. I was unaware that that this happened, but at least according to the client, it was the only thing that could have happened. He had recently left the military, and he had had a non-judicial punishment for possession of a small amount of marijuana. It had not went to a court martial. It was non-judicial punishment, Article 15, and somehow he still had the presumption in there. And so that's a little quirk. Not only is it the actual use even for medicinal, but they still have some of these real archaic issues surrounding that. So for those who are looking to marijuana legalization, we need the federal legalization to happen before it will click in with the states properly.
And it is just to follow up a little bit there, it is a rebuttable presumption. What does that mean for you? Brings us back to what we were talking about defensive incidents previously, what we talked about with trespassing. It's a defense, okay? You'll get arrested, and then you can show that you are not an active user. And in the Fourth Circuit, where we lied, they have to show a pattern and recency of use to convict you for being an unlawful user in possession. So you might have defenses if it was a single arrest 6 months ago and turned out not to be marijuana at all. I think you can win that case. I'd feel very, very confident in taking that case. But it's that old saying, you can beat the rap but not the ride. Who wants to go through that prosecution?
So Chad is asking about medical cards cross-checked when a person buys a hunting permit. There's no check when you buy a hunting permit other than you have to put in, you supply your driver's license number in the state that your driver's license is from. So you're either a resident or a non-resident, but they don't check to verify anything. As a matter of fact, you can buy a hunting license for someone else without showing any kind of ID or anything like that.
Good questions.
Mm-hmm.
I think
So
we've hit
if
them all so
nobody else
far.
has an agenda to talk about, I have something that Ed and I talked about ahead of time, which I think is useful, which is the second video that he was talking about. And we could spend several more hours unpacking those videos, which is not time I have to give tonight. But that second video where the gentleman was very, very calm, pulled out the handgun, backed the person off his porch, and started counting down and said, you've got 5 seconds, 4 seconds, 3 seconds, 2 seconds. This is where we talk about how a video camera can get you in trouble. And this is where a video camera, I think, could have been absolutely used against him if this had turned into a shooting. Because even if the person who he was backing off his porch had lunged at him and put him in imminent fear of death or great bodily harm, and he didn't have another way to avoid it, couldn't have stopped using any lesser degree of force, didn't have any duty to retreat, and the law was on his side, the fact that he had been counting down, if that lunge coincided with him getting to 0, would have absolutely been twisted against him, in my belief. I think that video would have been used by a prosecutor to argue this was a use of force because the clock ran out, right? It was like counting down to a kid, get in timeout, 3, 2, 1, and you didn't get in timeout, so you pulled the trigger. And so it's a great example of how a video can be, even when you're not doing something really wrong, can be used, and facts can be manipulated and massaged by a prosecutor to make you look like the bad guy. And so
and video is everywhere now. Everybody's Ring camera, everybody's phone camera. Wherever you think you're doing something, the video's going to come up. You got to count on it.
You know, I had a client very, very recently who had an interaction with law enforcement, And he told me, great news. I've got video of the whole thing. It will exonerate me. It will show that the other person was shooting at me before I started shooting at them. And they said, can I show it to law enforcement? I said, no, you can show it to me. And the video, although you could hear shooting, you couldn't see who started shooting at who. So the video did not do what the person had their personal knowledge and was filling in gaps with their personal knowledge, thinking that was what the video was going to show. That was not what the video showed. The video would not have been helpful. And so, I think this is what I'm really getting at here is you need to understand the scrutiny you're going to face if you're involved in a defensive incident, and even things that you might think are helpful. You might think this video of me pointing the gun at them and saying 5, 4, 3, 2, 1, you might think that's a helpful video, but you need to talk to a lawyer because you need to start looking at how could this be turned against me? How could a prosecutor take these facts and read something very, very different out of what I think is helpful?
Yeah, don't share anything till you talk to a lawyer. Make sure you.
I've heard a number of lawyers say that there is absolutely nothing you can say to the police that will help your case, but there is a lot that you can say that will hurt it.
Can we also talk about? I mean, I thought one of the things people might be interested in was that first video that was played. It didn't actually show the shooting, as I recall.
I think with the echo and stuff, it was just hard to follow anyway. But I can certainly get it, or we can just talk about it. Most people have probably seen it, I think.
Yeah, well, yeah, and there was an issue where again the boyfriend or ex-boyfriend was kicking in the door. He gets it. I think he broke the door open and was going in when he gets shot. Then it looks like he's trying to turn around and he gets shot again, but that's not clear. You don't know if he was just kind of moving and then going to lunge again. But the third shot, it looked like he was retreating. He had been shot twice and was walking away when the third shot hit him. But there was a cadence of bang, 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 a rhythm there, and it can be very hard sometimes to pull a shot if somebody at the last minute were to turn. I mean, if the trigger's already in motion, you may not be able to stop, the reaction in time that they're really late into turning around, and they could end up getting shot in the back or in the side. But this one, the third shot was a question for a lot of people, even though the grand jury said, no bill, and he wasn't the homeowner wasn't charged. There was a lot of fear that a lot of prosecutors might have gotten you charged with that. So, any comments from our attorneys?
Well, Gilbert and I had talked about this earlier as we were talking about this live tonight, and I'll let him go into greater detail on his thoughts. But the reality of the situation is, if the prosecutor had decided to prosecute based on that, you're going to be in a situation where not only are you paying for an attorney, but you're paying for an expert witness who has to testify to those physiological and neurological issues that arise when you're in a pattern situation, etc. And you're going to be trying to explain that to a jury, which is one of the most fickle creatures in all of the cosmos. So I'll let Gilbert go into more detail on that, but I will add one other thing about that video. Going up to that, I wanted to mention this earlier, and we drifted off. So, the controlling case law in Virginia says that mere fear of serious bodily injury or even death, however well grounded, will not justify the taking of human life. There must also be some overt act indicative of imminent danger at the time. And you'll hear when you're doing self-defense cases, always talking about that overt act. And we talked about words earlier, and words have to be accompanied by an overt act of some kind in order to transform them. In the case of the shooting, that the first video, if you watch some of the extended coverage, they actually show the shattered door frame where he had actually broken the lock through the entire door frame. And like so many houses, had a really sturdy door with a really sturdy lock, and it went into a little frame in the wall that, you know, had almost no strength, but it had gotten shattered off. And so, you know, those are the kind of literal details that are going to come into play when you're trying to defend yourself if you end up with the prosecutor that decides to prosecute. Now I'll yield to Gilbert.
And also, I mean, wouldn't that would be considered a violent and tumultuous entry? I mean, I would think that would make the point that this wasn't just somebody coming in, that you are actually under threat when they actually violently break into your residence. I would think that would be a strong.
It would certainly help. I like to call this sort of stuff the Goldilocks standard. And when I say the Goldilocks standard, what I mean is it's very, very fact specific and it's very, very time specific. Because if you wait too long to use deadly force, you wind up getting killed or seriously injured, maimed by somebody. But if you act too early, I mean, and we're talking milliseconds too early, you will be picked apart, especially when there's video. The prosecutor is going to play that video over and over and over again, and you will be picked apart and armchair quarterbacked, and someone will be saying, this was not yet an imminent threat. There was not yet an overt act. There hadn't yet been a substantial step towards the attack actually being carried out. You used deadly force too soon. Maybe it would have been justified, 15 seconds from now, but it was not justified right now because there had not been that substantial step. So when I say it's the Goldilocks standard, it is often easier said than done under stress. But you have got to get this stuff right, because if you don't get it right, you are exposing yourself to liability. So I think it's important that you understand. Yeah, go ahead.
So we spoke before, a couple years ago maybe, about let's say a guy gets there's a brandishing incident. He has to pull his firearm out, and now he's thinking, oh my God, this guy came at me, or his dog came at me, or whatever. I pulled out my firearm. I didn't have to shoot, thank God. But now I'm afraid he's going to call the police on me. And you said, if that type of thing ever happens, I would tell that person to call your office or call John's office and say, look, here's what happened. Then you call the police. You remember that scenario?
So I do, and I want to, just so I don't lose track of things that I wanted to talk about, I wanted to just reiterate what John was saying in the fact that in this situation where somebody had started to turn, you're absolutely looking at paying for an expert witness, and those expert witnesses are not cheap, because there's science out there on this subject. There's science that says once you've made the decision, once your mind has come to the conclusion that it's going to squeeze the trigger. And I took a class on this subject through an organization called the Force Science Institute, which was a wonderful class, but it takes roughly a half a second to execute once your brain has made that decision. And a person can turn in about 0.2 of a second. So what does that mean? It means at the point your brain has made the decision to squeeze the trigger because you're facing a threat, you're facing an attacker, it takes a half second to execute that. And during that half second, in roughly half of the time that it takes you to actually squeeze the trigger, somebody can spin and turn and be heading the opposite direction. And that could be how you wind up shooting somebody in the back in a justified shooting. But it's going to be difficult and expensive to explain. It's not that it's not possible to explain, but it is going to be difficult. It is going to be expensive. Turning to what Ed's just talking about, I do have some sort of general rules on when I think it's important to call 911. My general rules are, if you've shot somebody, you should call 911 before calling an attorney. It's not a good look if you are on the phone with your attorney while somebody bleeds out. If you point your gun at somebody in public where lots of other people see it, you should call 911, because you can virtually guarantee somebody else is calling 911. And then we want to be on the record that you two were calling, trying to get help because you were threatened. If we're talking about that third scenario where you point your gun at somebody who was threatening you, the person runs off, you don't know where they went, you don't think anybody else saw, that third scenario is where I recommend you talk to counsel, because I have absolutely dealt with cases where people think I'm doing the right thing. I'm going to call it in. I'm going to report this to the police. The police show up and the other guy's ran off. He's gone. And we don't know. Maybe he called the police too. Maybe he didn't. But there's one person left there that the police are talking to, and it's you. And you could be arrested for brandishing in that scenario. So why expose yourself to that liability? Talk to an attorney before you make that call and let the attorney assist you through that process.
And basically, to go one step further, Gilbert said he would call the police and say, look, I got a guy in this jurisdiction at this time that he had to pull out his gun. And if you just let me know if you hear about anything and we'll talk about it. Otherwise, we're done talking.
Yeah, and that's a privilege that I have as an attorney, is that I can do that. Now, I'm not saying you do that in every situation. It's very, very fact specific. Some situations I advise the person, oh yeah, we need to get this one reported right away. Other situations, I tell my client, hey, I know you thought you were right, but the law does not support you on this. And if you never hear another word about this, you need to consider that you won the lottery on this, because you're going to get arrested if the law enforcement finds out about this. And it happens. It happens where people think they did the right thing and the law doesn't back them up. And so if you have a situation where you can afford the luxury to talk to an attorney before calling and tattling on yourself, you should take advantage of that opportunity.
So Chad's asking if he can cut the grass with an AR strapped to his back.
We're assuming that his lawn mowing is not a permitted event, nor is adjacent to an event that would need a permit. And I only half jokingly say that because of our destruction of preemption that the last administration has brought us into. But having said that, in general, the general rule is that Virginia is an open carry state. And as long as you are not brandishing a firearm, I'm assuming that it's slung and not being handled, the answer is yes. Now, as Gilbert and I have said multiple times tonight, just because something is legal doesn't mean that either a neighbor couldn't harass the police to come in and talk to you about it, and or a prosecutor could not indulge in overreach. So always keep that in mind.
I see that somebody, George Face Pulliam, said that he got arrested for crossing. He was 8 miles into Maryland and got arrested for having a handgun there. He's asking about reciprocity heading to the Supreme Court.
Well, she contradicts herself, too. She has a Virginia handgun in Maryland, so that's not legal. It's not illegal Virginia handgun if it's in Maryland.
The question here is, though, the reality of the matter is, if the arrest just happened, we now have the Bruin decision. The real question is, is this something that you and the attorney that you've selected are willing to take all the way? You actually are in a fairly interesting circumstance to try and apply Bruin to that situation. Unfortunately, I suspect the answer you're going to get is, because Maryland does now offer a non-resident permit, they're going to argue that you did have an option for carry and didn't avail yourself of it, and that states are not required to do reciprocity. They're just required to offer a method by which one can carry. And since Maryland can now argue that they do, that's a tough spot, and I'm so sorry you're in that situation. And I wish you the very best, but I don't think reciprocity as a right has a chance to win, even in this Supreme Court.
And it's generally unhelpful that it's easier to obtain a Virginia concealed handgun permit than it is to obtain a Maryland wear and carry. Because if the inverse were true, if it were more difficult to obtain a Virginia, more stringent requirements to obtain a Virginia concealed handgun permit, I think there are some other constitutional concepts out there that would say, hey, this is something that should be recognized. Unfortunately, there is case law out there that I think, even in light of Bruin, is still good case law that says states are not required to accept licensing from other states or permitting from other states that is less stringent than what they require. And this is not just in the context of firearm, it's in context for all different sorts of licensing and permitting requirements.
And, there's a couple of problems, like your lawyer said, the money and the time. It takes years for a case to work through the system and get to the Supreme Court. And it takes lots and lots and lots and lots of money.
Yeah, I was going to say, and yes, in answer to her question, an out-of-state resident can apply for a Maryland permit. I've had one for 3 or 4 years now, so yes, you can apply. Now it's a pain if you have to take a 16-hour course. It's not, other than that, it's not expensive. It's $75, I think, for 2 years the first time and 3 years after the first renewal. And maybe that'll change at some point, but yes, you could apply. And we've had people apply and within 30 days have gotten their Maryland permits.
Yeah, I wouldn't say that's not expensive, especially when you factor in the course that you have to take. But you shouldn't have to pay to exercise your rights. But there is a venue to get a permit to carry in Maryland. I did want to touch on Michael Dalton has a question for a friend. Is there a time block after which a person can apply for reinstatement of gun rights after receiving a felony charge, but clear record before and after?
The key question is, have they had their political rights restored by the governor? If they have had their political rights restored by the governor and they're free of all supervised probation, then statutorily they can go. The real question is, will the judge in my jurisdiction entertain a petition if it's not been 5, 7, 10? Different judges, I think, have different yardsticks. Humans have 5 fingers, and subconsciously 5, 10, 15, those numbers resonate well with us. I generally recommend that people wait a minimum of 5 years. I have had some extraordinary circumstances, people who wanted to join the military, people who had legitimate business reasons, where we've managed to get their rights restored sooner. But in general, we're looking at a situation with where I'd recommend waiting 5 years, and again, making sure you've got your political rights restored.
And the nature of the charge matters. The nature of the underlying felony for which you were convicted is going to have a huge impact on how the judge is going to look at you. There are certain felonies that I talk to people that it's been 7 years since they were convicted, and I tell them you need to wait longer because look, I'll take your money if you want me to try, but my advice to you is this is not a good, you need to have more of a history clear from this before this is likely to succeed. There are other felonies that I'm even comfortable sliding in under the 5-year rule, general rule that John's articulating, because I say, look, this is, yes, it's technically a felony, but, I think we can convince the judge that you are somebody who is deserving of the restoration of rights. So I would tell you, I agree with John. I think 5 is a good baseline to look for, but depending on the nature, it might be a whole lot longer than that.
And actually going back to nature, just to wrap this up, we're seeing more and more judges around the Commonwealth that have begun adopting the position that there are certain situations where even though statutorily you're entitled to apply, that they're always going to deny, and specifically anything where you remain on the state sex offender registry. The judges are pretty unanimously stating that since the standard they have to satisfy is that you're no longer a threat to yourself and others, that by dint of the fact of being on the registry, that you can't say that you're not a danger to yourself or others, that the General Assembly's already made that determination. So yes, very much the nature of the offense will come into play there.
And Chad is asking, does the person have to appear before a judge or write a letter?
They need to hire an attorney, and you'll almost always have, and I know that sounds so self-serving of me to say that, and I apologize for that, but it really is true. I mean, I've known people who have gotten their rights back pro se, but it is rare, and more importantly, they don't have the other things, the aftercare that we provide, explaining all the things that they need. How do I fill out the paperwork when I buy a gun from now on? How do I fill out the paperwork when I get a concealed carry permit? Are there federal laws maybe that still cause me problems? What about other states? There's a lot of aftercare that you need. But in addition, you know, you generally do have to appear in front of a judge. There are very rare cases where we can get judges to restore without appearance. But again, you need to have a long, like 30-minute discussion with me or Gilbert or someone like us so we can tell you what your chances are of that.
The other thing to add there is there's a lot of ways you can mess it up going alone. I have seen people that have had things that they say are gun rights restorations that are ineffective to actually restore rights. And, you know, sometimes it's because judges think they're doing somebody a favor and judges don't realize what they're doing. But there are examples out there, and I'm sure John's seen them too, where people walked out thinking they had gun rights and they didn't have gun rights.
And I just want to reiterate here, because just getting a lawyer is not good enough. You need to get a lawyer that specializes in firearms laws in your state where you're getting your rights restored. John and Gilbert both spend a lot of time and even know more about firearms law than some of the state officials do. And, you know, they work with the Virginia State Police, they work with the judges, and they can help you and actually save you money by hiring the right attorney. So quality matters in that case.
I noticed Georgia had another question here, and this is going to be a problem for her. She says, if I'm convicted of a firearm misdemeanor that carries up to 3 years in jail, will I be able to purchase a firearm and carry concealed in Virginia? No, you won't be able to. You will be a prohibited person under federal law. And again, the attorneys can contradict me if necessary. But that's my understanding. If it's over a year, and there are some misdemeanors that go
2 years.
2 years.
Two for misdemeanor.
So, and the statute actually says 1 year, and then we have a regulatory redefinition that changes the 1 year to 2 years. But so it is 2 years, but yes. And the states that have that problem, we have South Carolina, Maryland,
Pennsylvania.
New Jersey, Pennsylvania, and Massachusetts. Those are the 5 that have misdemeanors that can have more than 2 years.
And can you get your rights restored after a misdemeanor conviction like that, or it has to be a felony?
It depends on state law.
Yeah, what I would tell Georgia is I would fight this case like hell to not get that conviction, because it's going to be a real problem.
And it's so important that Georgia knows that it doesn't matter if she's convicted of that and gets 1 day suspended. It doesn't matter that all she got was 1 day. It's the fact that the code that she was convicted under has a maximum of more than 2 years. So oftentimes what we'll encourage people to do is to have their Maryland or other state attorney say, look, okay, fine, they're going to have to take a conviction. Can we please change it to a different misdemeanor like obstruction that has a lesser maximum sentence? They'll take the exact same conviction and whatever jail time or whatever fine, but let's not take away their lifelong time rights. And it's important that you make sure that your attorney's aware of that if you're charged in one of those 5 states.
Yeah, I don't know if she wants to talk the Maryland shall issue. She might want to do that, Georgia. Their president's an attorney, gun attorney. So you might want to give them a call as well, just to make sure that everything's handled right here, because there's a lot riding on it.
And just for the sake of clarity, because there was some back and forth, and I want to make sure that we're clear on this point. Philip had originally said 1 year. John said 2 years, and they're both right. It depends on the grading of the offense as well, because if it's a felony, it's 1 year. If it's a misdemeanor based state offense, excluding domestic violence related offenses, that's what triggers that 2 year limit. And so just important that we understand that.
Thanks for clarifying.
And Militant was asking, is Virginia open carry for only residents of Virginia, or can other states that have reciprocity? Reciprocity has nothing to do with it. Unless you're a prohibited person, then you can open carry in Virginia if you're over 18. With some, everything. There's caveats now for everything. It depends on if you've got a firearm that's got a threaded barrel and you're in one of the counties that you need a concealed handgun permit. But if you don't have a threaded barrel and you don't have a magazine over 20 rounds and you're not a prohibited person and you want to open carry your Kimber 1911, then you can do so. And you know, there's always these people that'll come through and be like, yeah, but it's got to be seen on 3 sides, or you can't have a round in the chamber. All that type of stuff is dust in the eyes or BS. Someone tells you that, tell them to show you the code so you can look up the law yourself that they found, or talk to us at VCDL when you write in and ask your question. Make sure you include your member number, because we try and help our members first than just Joe Blow public. Membership's only $25 a year, and we'd like every member that can to support us. All right, we're coming up on 9:30. We started at 8 o'clock. I think we could probably take another question or two and then start a wrap up. What do you think?
Yeah, sounds good.
Let's see. And I guess, if there's no questions, we can let John and Gilbert, or actually anybody, come up with a closing thought before we. I think this was a great session, a lot of lively discussion on a lot of things that we covered. Hopefully you guys will reshare this video to your gun friends that, you know, maybe have a long commute and they don't have to see our pretty faces, but they can certainly learn something by listening to the replay of this. Maybe save themselves an arrest or a court appearance.
I know I'm going to post it on my business Facebook page, because I think a lot of my customers will benefit from the knowledge that was shared here. I want to thank John and Gilbert both for taking the time. They're pretty busy attorneys. And
yeah, we're pretty lucky that we've got 2 attorneys on the board. That's a first. We've had one for many years, and then we didn't have any for a little while. But that's a huge resource to have somebody with their knowledge on the board. So we got 2 of them. Now, I don't know if we need 7 attorneys, but having 2 is certainly something that we're blessed with. They certainly both fielded a lot of questions by me and others internally as we're working our way through writing an alert to make sure I'm not saying something that would be contradictory or not correct for laws, things like that. Just tons of stuff.
And that's a lot of times why on the page, the VCDL page, I post things from the alert or things of interest or whatever. But on the VCDL group, we're very specific to Virginia gun rights. And the reason is because, as you saw the way the scrolling comments were here about what Virginia law says, in the group, people will post what happened to them in Maryland or North Carolina or DC, and it gets out of hand. And then people think, oh, I can open carry here or I can't do that. And they're talking about their home state somewhere else, and it actually gets people in trouble. So that's another reason why in the Facebook group we limit it to Virginia gun rights only, in case anybody wanted to know that. All right, well, that's everything I had on my list. Unless anybody else has anything, we'll wrap up and call it a night.
Yeah, in closing, I would just say thank you for doing this and putting this together. I think it's a fun evening to share and talk through some important issues. So I appreciate it.
It's always an honor and a privilege to help out our members, and proud to be a part of VCDL, which is doing so much good work on behalf of Virginia's gun owners. And so it was a great night.
Yeah, our philosophy has always been that we want our members to be well educated, and they are. Again, I often point out that I've seen impromptu interviews with members by the news media, and they've done a great job. They know their stuff, but we want you to know the laws. We don't want anybody to get in trouble, and this is all part of the mission. And I'm glad that a lot of people will be checking this out and making sure that they know the laws, because there's too much at stake all the way around not to know them.
Yep. And I would be in big trouble with our PAC director if I didn't put in a shameless plug for the Top Gun fundraiser this coming Saturday in Powhatan, Virginia. You can still sign up this week until Friday, through Friday, vcdl.org/top-gun. Shooting competition, dueling trees, $125 entry fee, $1,000 prize, or you can come and just have barbecue and cheer on the competitors for $40. It raises money for the Political Action Committee, which helps to elect candidates that will overturn some of these terrible gun laws that we got in 2019 and 2020. So if you're anywhere near Powhatan on Saturday, come out and join us.
All right. Thanks again, everybody. Have a great night.
Thanks, everyone.
Good night.
Good night.